All right, at this time, this court calls the last case on the docket, State of Kansas versus Eric Miguel Camacho-Rodriguez, case number 126826. And parties, you do not need to make your appearance until you come to the podium.
Good morning. May it please the court, Carol Longenecker-Schmidt on behalf of the appellant, Eric Camacho-Rodriguez. Judge Pickering, if I may, I would like to reserve 3 minutes rebuttal.
3 minutes is granted.
Today, Your Honors, my intent was to address mostly the second issue in the brief, the Batson issue, and submit issues 1 and 3 on the brief, unless Your Honors obviously have other questions. But that seems to be the issue where there's the most kind of up for debate, I suppose. My understanding is that the state is conceding that the district court erred when it determined that the Batson challenge to the alternate juror in question here was not ripe. I think the state is arguing and agreeing that the district court should have addressed that issue right then and there and not waited to see if an alternate ended up serving. So I think we're in agreement on that. I think where we diverge is that the state is arguing that that error was harmless for a couple of reasons. And the way I'm separating it out is sort of a big picture and then sort of factually specific to this question, to this case. Big picture, our argument is that Batson violations are about more than the jury verdict. They're more than actually who ends up specifically serving on the jury. They are a structural error. I think the state is saying that because no alternates served, the alternates weren't even really part of the structure or part of the process necessarily, so we don't even need to get to that question. And my argument is that that's not true. So once ER was struck, that's when the harm occurred. Part of the Batson analysis, specifically in the third prong, is not just looking at the specific challenged juror, but also looking back at previous strikes. And in this case, defense counsel said, well, this is the third Hispanic potential juror that the state struck. So it's not just about that specific juror that was struck. It's also a more comprehensive look at how the prosecutor exercised peremptory strikes throughout all of voir dire. And so if the district court judge had addressed the third prong, he would have been looking at the specific characteristics of ER, the demeanor, and the responses that ER gave to questions, but also looking back at these other previous strikes that the prosecutor had made. So there's a potential here that even though we're focusing in on ER here, we're actually looking at the whole process of voir dire. If there's a determination that the prosecutor was using discriminatory intent in striking ER, that could also extend to the previous ones too. I think that's what the defense counsel was saying. They look at all the circumstances of the voir dire. And so then if that's the truth, or that's what happened, and we don't know because the district court judge didn't make that final ruling, but if that's what happened, it's really irrelevant that the specific challenge juror was an alternate, because you're having a prosecutor exercising strikes when they were exercising strikes on the general panel too, not just the alternate panel, if that makes sense. Alternates are sworn in. They're part of the process. It also matters what the litigants, the people in the gallery are thinking when they're watching a trial happen. They don't necessarily know who is an alternate and who is a main juror. They're just going to see, a bunch of white people. And so our argument is it's about more than just specifically the verdict and just specifically who served on that final panel, that the harm extends beyond that specific alternate. I think the state is also saying that if the error here is harmless because even if the district court had made that final third ruled in the third Batson step, it would have concluded that there was not not enough there, that defense counsel hadn't presented enough. And the state can obviously correct me if I'm misunderstanding this. Our argument would be that's for the district court judge to determine if there's enough. Body language was one of the main issues here, and all that, though that can be one of the race-neutral reasons for step 2, we're at step 3 now, and the district court judge needs to look, okay, do I believe that? Is that plausible in light of all of the factors going on here? We don't know what that body language was other than a chip on the shoulder. All body language is not equal, is what I'm saying. And the only person who can really evaluate the plausibility of the prosecutor's, reliance on body language is the district court judge, the people in the room there, and not any of us.
So then whose responsibility is it to ensure we have those findings that are made? I mean, we can't make them now. And so what do we do when we don't have a record of those kind of contemporaneous evaluation of the arguments and the factors?
My argument is that this court should remand for a proper Batson hearing, and I do understand the procedure's kind of awkward there to go back and do that. But there are cases of this court, of Kansas appellate courts doing that. And I think it's the Bolton case that toward the end has a description of what that remand hearing should look like. And it's, send it back for, you can re-argue the same things. You can look at the record, like what we have. I don't think you can present new evidence. But the important part is, even though we're way after the fact, and this is not ideal, the important part is you at least have the people who were there in the first place to make those factual findings. It's not great.
And how practical is that, really?
I don't know. It probably depends on a lot of factors. I don't know here if there was a live transcriptionist or if there was a recording. If there's a recording, you can hear voice, tones and get a little bit of a different sense of what's going on. This was COVID times, and I don't recall if there was any Zoom. It's not very practical, but it's the best thing we have, I think. My argument is that it can't be true that all Batson violations involving alternate jurors are harmless if no alternates serve. Because you could run into a situation where a prosecutor makes an inappropriate strike and says something awful on the record, like blatantly racist, and for some reason maybe the judge, doesn't pick up on it. And so you have this glaring, blatant racist Batson issue here, but it's harmless because I think the state would say it's harmless if an alternate doesn't serve.
But that's separate from the preservation issue. I mean, we're kind of back to the structural error, but my concern is kind of this preservation issue and our lack of findings to really analyze it, and just kind of the impracticality of sending it back now and trying to have the district court recreate something. I mean, my concern is we're rewarding a defendant for not making a record below and still allowing it to go back for some recreation.
Sure.
And what's the effect of that ultimately going to be?
Sure. I mean, some courts honestly place the responsibility on defense counsel, right, to object, and object again. And defense counsel did not object, 6 times, but defense counsel raised it. And my argument would be that the district court judge just said, well, we don't need to consider it. You're preserved for appeal. I think the judge said that twice. You're preserved for, I apologize. You're preserved for appeal. We don't need to reach it yet because it's ripe or it's not ripe. You're preserved for appeal. My sense is if the defense counsel had said, well, hold on, I want you to make factual findings. The judge had already concluded it's not ripe. I don't need to make findings. So I'm not sure that an additional objection would have gotten that. I agree it's awkward, and
Can I ask you your understanding of how the voir dire process was done? The difference between the 12 and then the alternates, because that was 2 separate steps, right?
Right. And I don't see it done like that everywhere. Often you just make your strikes and then draw for alternates. So it seemed,
right.
I think they each had 12, or I think they each had 12 and went through it, and then they said, okay, now you each get to make 2, and those are going to be the alternates.
In a pool, it's something about a pool of
Right.
6 alternates, then you each get a strike,
Right.
at least one, I think. So it was a separate, which is interesting to
It
me.
was interesting, and the charts where they make their strikes are on, they start on page 94 of volume 1, and they're kind of hard to understand because there's some things that are crossed out and some arrows. But I think that by the time they had each made their 12, they were down to 6, I think, and then they made 2 each.
Well, why that's important to me, obviously, is your argument earlier about was the original 12 tainted in some way potentially? And I'm saying I'm interested in how the alternates were done completely separately after the initial 12 were selected.
Right. I think they were all done at the same general time. And I think that the few times that appellate courts have addressed this question about, alternates, when you look at discriminatory intent, I think you look beyond the alternate pool. You would go ahead and look back at the general pool too. So I think it's kind of a false distinction, even though they drew that line. Yeah, it was odd. I'm not sure if I have any more helpful things to say on that.
You have about 1 minute left. Did you wish to conclude, or?
My conclusion is just to request that this court remand for a proper Batson hearing. The district court's the right court to make those factual findings, and we might end up back here, but it's the best solution we have.
Thank you, counsel. Appreciate it. Right, you will have your rebuttal time. Mr. Maloney, you'll have 15 minutes.
May it please the court and counsel. Assistant District Attorney Matt Maloney for the state. I'll also focus on issue 2 here today. I think Your Honors pointed out correctly that there's really, I guess, 2 separate things as part of defendant's argument. One would be this issue of whose burden was it below when it got to that 3rd step. And we do acknowledge that the first 2 steps really aren't an issue here. And the court, so it does get down to that 3rd step. And at that 3rd step, this court reviews for an abuse of discretion and gives significant deference to the trial court. And I would start off by acknowledging that counsel's correct. We acknowledge that I think it would have been appropriate for the district court to rule on the issue at that time, that this was not something that was not right. Because I think just logically speaking, if you don't rule on it at the time that counsel raised the argument below and you wait until the end of the process, then obviously you've already gone through the trial. You really can't go back to the beginning. And so we do think that it was raised at the appropriate time below. But our issue is that after the state had provided its race-neutral reasons, the district court gave the defense attorney a chance to address those reasons. And counsel didn't really do anything about the reasons that the state had articulated, didn't challenge those. I think all counsel really did at that point was to just point to the fact that, well, the state had already had already used a strike against somebody, another person who was Hispanic, but they did not address the reasons that the state gave for striking ER, which was body language and some specific concerning answers that that ER had given. So because the defendant did not address those, that's why the court was not even, it's not a matter of the court not having given the defendant the chance. The defendant was given that opportunity and didn't try to do so at that point. And so that's why, to the extent that the record is lacking, that's the defendant's burden, and it's not something that needs to be remanded when the defendant himself is to blame for the lack of specific rulings on those reasons that the state articulated.
So how does that work then? The state presents their race-neutral reasons, and then you look to the district court, or you look to the defense attorney to counter that?
Well, I think I cited Brown, which was a case where our Supreme Court said that essentially at that 3rd step, the burden is on the defendant. And so in the Brown case, I think what happened is that when it got up on appeal, the defendant was trying to challenge that third step, but he was raising issues or specific arguments that he had not raised below. And they said, no, we're not going to, it's not the district court's job to sua sponte address reasons that the defendant failed to argue below. And so I do think that it's on the defendant at this point, and it was on the defendant below. And so I don't think, to counsel's point, that this case should be remanded for exploration of those issues. I would disagree, because I think he did have the opportunity. If our facts were different, let's say the district court had prevented defense counsel for whatever reason from responding to the race-neutral reasons that the state gave, then I would probably agree that in that situation, some sort of remand would be appropriate if the defendant was not given the opportunity when he tried to do so. But when he was given the opportunity and he simply chose not to do anything about that, then I think there's no need for a remand, because again, it's not the district court's job, and it's certainly not this court's job as an appellate court to sua sponte address those issues. So then that leads us to the structural error argument that the defendant has made. And I cited in the brief multiple cases, but I think the Dixon case, the Nevada Supreme Court case, is the one that really summarized and synthesized all those cases.
Can I interrupt you? I just want to make clear. So you're not conceding any error at all in the Batson analysis, correct?
I think...
I want to clarify that.
Sure, no, exactly. Yeah, I think that the error would be to the extent that the court said that he didn't think that it was ripe. Then I do think that's a mistake. But I think that because before that, the court had already gone through basically the process of, okay, the defense raised the challenge. Now I'm going to have the state give their race-neutral reasons. Then I'm going to give defense counsel a chance to respond. So really, they went through the three steps. So that was not an error. I think the error was then basically after that saying, well, you know what, because it's an alternate, I don't know that we need I don't need to actually rule on it right now, and it only becomes ripe if one of the alternates serves. So I think it went through all the right paces. It just failed to then go ahead and make the ultimate ruling.
Okay, thank you.
But returning to the structural error, I think the Dixon case does a good job of explaining why this is not structural when it is an alternate or a potential alternate. The language about structural error, and this court's well aware that there are very few errors that are structural in nature. And essentially the case law talks about it has to be something that affects the entire trial process. And here, it's structural because there's essentially no way to determine whether the error was harmless or harmful. But here, we can know beyond any shadow of a doubt that it had absolutely no impact on the trial process.
But counsel, it's my understanding that when we're looking at structural error, it's a little more foundational. I mean, your friend on the other side is mentioning it goes to just the inherent wrongness, for lack of a better term, of the behavior, the perception of fairness when you've got the defendant sitting there looking at a jury that maybe doesn't reflect what they think a fair jury pool should be. So if we're looking at it from that kind of broader sense and more foundational aspect, does it really matter if the alternate participated?
And I appreciate that question. I think in this case, our facts, and to your Honor's point about the way that this was done in this particular case, is that it was separate from the selection of the 12 jurors that ultimately were impaneled. They had already finished the entire jury selection process. The parties had both used all of their strikes, and it's noteworthy that the defendant never raised a batching challenge to any of the jurors that were in that the group that actually served. And so I think part of the argument that the defense is making today is that, well, it could nevertheless have affected things because maybe it bled over. Maybe there was something in the jury that ultimately did sit that was, related to whatever reason. But I would argue that if that were the case, obviously the defense had every opportunity to argue that the state was using improper bases for challenging or removing jurors from the panel of 12 that actually sat. So I think in this case, just especially due to, and I would agree, I think this is a fairly unusual way. Obviously, I don't do trial work, but in the transcripts that I review, I haven't seen a lot of judges do it this particular way, where you know up front that you're separating out the panel from the alternates. But because you already went through the whole process with the panel and the defense never raised a Batson challenge, I think it's pretty telling that the defense itself did not see any issues with the jury that was selected. And so that's why I think it further supports an argument that there is no concern that this was something that affected the trial process at all. And I think at the conclusion of my brief, one of the
But again, you're still talking about the deliberation process ultimately, because you're focusing on those 12 jurors. And it's my understanding that in addition to that argument, your friend on the other side is talking about just the perception of fairness and the inherent, problem with this at all, and how it kind of infects the whole process and the perception of the defendant, and maybe even the perception of the other jurors who are participating and seeing how this happens.
right. And
how do we address, if it's that fundamental?
I guess I would again respond that if there truly were that fundamental a failure, that it would have been raised by counsel at the point where defense counsel had the opportunity to challenge the makeup of the initial jury. And especially given the fact that we know that this defense attorney was not reluctant to raise a Batson challenge if they felt it was warranted, because they did just that to the alternate. So I think you'd have to somewhat turn a blind eye to what actually happened in this case. And that's why I think, again, the Dixon court talks about the fact that when you're looking at structural error, it's oftentimes because you really can't determine whether there was or was not prejudice based on an error that happened. But here, and I think it's noteworthy that really in my research, and I think the Dixon court does a good job summarizing it, I think the vast majority of state and circuit courts that have addressed this have come down on the side of it is subject to harmless error analysis. I think there was really just one state or one outlier court that I found and that I cited in the brief that did hold that it was structural, but that was very much in the minority. And I think some of the courts, and I understand counsel's argument today, and she said, look, it shouldn't be, the rule shouldn't be that it's automatically deemed harmless just because it was an alternate. I don't know that that this court would need to answer that question, because I think you certainly could just decide it on the facts of this case. But I do think that it's noteworthy that it does appear that at least some of the circuit courts that have addressed it, or some of the state courts that have addressed it, have flat out said that if it's an alternate that we're talking about, and no alternate ends up serving on the final jury, then it essentially is automatically going to be deemed harmless. Because
So in your situation, we could have even more overt discrimination on behalf of the prosecutor. And in excluding, say it was even more overt.
Sure.
But it's an alternate juror, and they never serve. So under your scenario, they could be, that would be harmless because they never served.
I think that is what many of the courts that I cited in the brief have held. Again, I don't know that we need to ultimately reach that issue in this case, because I think on our facts, they are strong enough to show that it certainly was harmless in this particular case.
But if we adopt the test, if we adopt the harmless error test, isn't that a potential application of it?
It is one potential application. I guess obviously this court would be free to fashion a harmless error test where it does look at more than just whether an alternate ended up serving. I'm sure there are ways that this court could do that and tailor it however you desire, because this is basically, to my research, this is a first impression issue in Kansas when it comes to an alternate like this. But again, I think that for whatever reason, the court in this particular case chose to separate out the selection of the 12 and the alternates. I don't know that, I think it just probably by happenstance that in this particular case, it turns out that that does make it easier to analyze whether there was any impact from this. And again, our position is that there was not. And again, just to wrap up, the final point that I made in the brief is I think that we do need to recognize the distinction between a Batson violation on the one hand and an error in the procedure that was employed by the trial court. So here, to the extent that the trial court did err by not articulating a final ruling, that is not a Batson violation by the state. If there is obviously, if there's a Batson violation by the state, I would certainly acknowledge that yes, that is something that is reversible and should come back. But that's not really what we're talking about here today. It's the process by which the district court ruled in this case or failed to make the ultimate ruling. So I would urge this court to keep that distinction in mind in looking at this, because I know that obviously Batson is an important tenet of the law, and we would never suggest that it's not, and we would never suggest that if a prosecutor discriminated on the basis of race, that we could just overlook that. But that is different than looking at the process here. And again, going back to Judge Klein's question, we think that the district court did everything right in those 3 steps. For whatever reason, he decided that it was not ripe to make the ultimate ruling, but our position is that the record here is sufficient to allow for review, because we see the reasons that the state articulated, and then we see the fact that the defense attorney never tried to challenge those bases when he responded and was given the opportunity to do so. So our position is that the record in this case is clear that any error that the district court made was harmless, and therefore we would ask that the defendant's convictions be affirmed.
Thank you, counsel.
Thank you, Your Honors.
All right, Mr. Schmidt, you have your rebuttal time.
Just briefly, if I can, because the thoughts are all over.
If you need a moment, we have plenty of time.
I'm not sure if a moment will clarify them.
Okay.
I wish, it would be a long moment. I think my argument is, well, first of all, the defense counsel did try to cut in and offer a little bit more. Could the defense counsel have, offered a lengthy statistical analysis? I mean, they can always do more. I've only done 1 trial, but it's hard, you gotta get in there, and the judges sometimes are terrifying, no offense or anything like that. But, the defense counsel did say, Your Honor, if I may, here's some more information. I think that the judge still had an obligation to make a ruling, because ultimately the judge is trying to decide whether the prosecutor's purported reasons, even despite, what defense counsel says. Defense counsel has the burden, but the judge still has to make a ruling on that, still has to decide whether the prosecutor's reasons are plausible or whether they're just pretext for discrimination. I'm not sure that the harmless error test, I'm not sure how to tailor a harmless error test to facts and then not get down the rabbit hole of looking at the outcome of the verdict. I don't know how that would be possible. It seems like the more you try to tailor a harmless error test, the more you're just going to be looking at, did it affect the outcome of the verdict, which overall is not the question for Batson, because we have this underlying equal protection principle here. And Batson talks about, this is about race, but you can't assume just because you have a white jury, they're all going to vote for white people, or you have a black jury, they're all going to vote black. It's tricky, because we're trying to prevent racial discrimination and get this cross-section of the community, but we're also not making assumptions that people of certain races vote certain ways. So I'm not sure how, it feels like if you tailor the harmless error test, you're going to start getting into speculating how people vote based on their race.
Well, I think what Mr. Maloney's saying, though, is that it's not a true Batson issue.
Sure.
The court handled the Batson challenges, may not have ruled on it properly, but then it really is a procedural issue, not a true Batson issue.
And I think if that's, the district court abused its discretion and made a mistake of law. And I don't think this court can determine that it was harmless because this court doesn't make factual findings. This court remands to the district court for that court to make the determination about demeanor and make that finding, as awkward as it may be procedurally. Unless your honors have any other questions, I'll just wait.
So let me just, let's, all right, so your thought would be come back, bring back all the jurors. I just want to walk this out.
Sure.
Bring back all the jurors, they're sat, put them in the jury box, have those 6 that were there, bring back the defense attorney, bring back the state, bring back the defendant, have the judge sit, and then recreate the argument of Batson. I'm just trying to figure out how you would do this remand.
I would look at State v. Bolton, pages, so that's 271 Can, 538, pages 544. Well, I think it starts later than that, actually. 544 to 45. So trial court remand does not involve the presentation of further evidence, but argument. So they're going to bring back the attorneys, I think, the defendant, and they look at the record and counsel's recollection. So I don't know that they need to pull the jurors back in.
I wouldn't think so either. I would just
Yeah.
think they would just need the attorney, the state,
Yeah.
and the, would you bring the alternate jury?
I don't know. I don't know because
You wouldn't, right?
I don't think I would, because there's a line in Bolton also that says something like, if the court can't determine whether it was a Batson violation, then a new trial is warranted. There's a line in there that feels very like, wow. I don't think so. It feels odd though, because the harm's inflicted on the community, the defendant, but also on that individual juror that was struck. So it feels weird to not bring that juror back, but I don't think practically, I don't know practically how you would bring that juror
So
back.
you would just probably read the transcript and then from there make arguments.
Right, and then, yeah, the attorney's recollections, the judge's recollection, hopefully they have some recollections. It's the best, I think it's the next best solution. So,
Right, thank you very much.
thank you.
All right, we'll have this matter under advisement.